Good morning, everyone. We just have a few more people in the waiting room that are trying to join us. Good morning. So happy Wednesday, happy sunny Wednesday. So I'm Gil Price. I'm the Executive Director here at Condominium Law Group. I think everyone knows me by now. And we have a number of questions that have been submitted. That is excellent. We appreciate that. So Zoom housekeeping details. Everyone is on mute at the moment. If you'd like to ask a question during today's Zoom, you're welcome to unmute yourself or use the chat feature. Valerie and I will be monitoring the chat feature today, and one of us will be sending a message to you just so that you can double check that. How do you find the chat feature? If you go down to the bottom of your screen, the Zoom toolbar is there. Click on the chat feature. That'll pop up. Valerie just sent a message to good morning, everyone. If you want us to see you, click on the stop video. We have, I think that's it. Let's see, do we have any public service announcements, Ken and Valerie? Hopefully you were at the Law Day last Saturday. If not, I think the next big event is going to be the Made for Managers Day for our community association managers in early June. So I'm going to stop talking. I'm going to mute myself, monitor the chat. Welcome. And we've got Valerie Oman, who's going to kick us off this morning, and Ken here, both partners at Condominium Law Group. Thank you.
Thank you, Gil. Good morning, everybody. Thank you for being here with us. I hope that you've been enjoying the weather and not complaining about how hot it got, because just wait till next weekend. It'll be 57 degrees and rainy. We wanted to start today, as we usually do, with a quick update on the status of Proclamation 20-51, which is the proclamation that most directly affects community associations. The proclamation remains in effect. There has been no change to it. And the last time the governor updated it, rather than giving it an expiration date, he indicated that it would be in effect until it was either rescinded or until the state of emergency around COVID-19 has ended. Neither of those things has happened. As a reminder, or for those who are new to this Q&A call on Wednesday mornings, Proclamation 20-51 prohibits associations from charging late fees and interest on unpaid assessments. And it also authorizes associations to conduct their meetings remotely or virtually, as well as vote by mail. So even if your governing documents would not otherwise allow remote or virtual meetings or voting by mail, those things are authorized by the proclamation. Related to the proclamation, I wanted to give you all an update on the status of Senate Bill 5011. Last week, we shared with you that it had passed both chambers of the legislature, and that has not changed, of course. There is a bill in its final form that has not yet been sent to the governor's desk, but will be shortly. And after I'm done with my talking part this morning, I will pop a link into the chat so that you can see the text of the bill as it has been approved by the legislature and as it will be sent to the governor's desk for signature. Our lobbyist updated us all at Law Day this past Saturday with an indication that the bill is going to be signed and take effect by July 1st of this year. So that is good news and a timeline, which is helpful to have, and one that we haven't had before now. So our expectation is that Senate Bill 5011 will be signed by the governor and will take effect on July 1st of this year. And in connection with that, we also understand that the proclamation will continue and will remain in effect until the bill is signed into law and becomes enforceable or effective. So the provisions of the proclamation, in particular, that allow things like remote or virtual meetings and voting by mail, will remain in effect until the bill becomes law. We do want to point out one difference between the two, because we think there's a lot of confusion out there about what the proclamation does and what the bill does. One thing that the proclamation does not do, but that Senate Bill 5011 does do, is authorize electronic notice to your owners. So Proclamation 20-51 does not provide for electronic notice. Senate Bill 5011 does provide for electronic notice. So that's one difference to make note of. And also remember that when the bill takes effect, electronic notice is authorized, but only on an opt-in basis. So you can't force your owners to accept notice by email, but you can give notice to owners who have opted in or elected to receive notice by email. And we also have a form, I think, a template form, opt-in form for electronic notice, excuse me, and we'll update it and I'll mention it in the next, several weeks as we continue to do our Q&As, because that could be a good resource for folks, for associations that have never had electronic notice before. You're going to want to have an opt-in form for your owners to sign up with once the bill goes into effect in July. Ken, did you want to comment any further on that stuff before I move on?
No, I'm good.
Okay, so we had a question that came in that was related to the Senate bill. And the question basically is about when the bill is going to be signed into law. The question says, with that bill, it seems that either the board could wait for it to be signed by the governor or proceed with an electronic notice amendment. Is that correct? Any idea on the timing of the bill being signed? So I think we already answered the question. The bill is we anticipate that it will be signed and become enforceable or, be signed into law on July 1st of this year. And we think the proclamation will remain in effect until then. We wanted to make some other comments related to whether an amendment, electronic notice amendment, might make sense for many associations anyways. And part of the reasoning behind this is that your owners are not aware of most of them, unless you've been sending out notices. Most owners are not aware of Proclamation 20-51, and they're probably not aware of Senate Bill 5011. So just like when WUCIOA was adopted in 2018, there are hundreds, if not thousands of people within your communities who are going to have no idea that this new bill is going to take effect on July 1st. And so when you first send out, electronic notice opt-in forms to your owners, if you have folks who like to nitpick everything that your board does in your community, which we all know that there are folks in communities like that, they're going to say, but the bylaws say that you have to give, or, the declaration says you have to send notice by regular mail. So one thing associations may want to consider once the bill does take effect is adopting amendments to your documents that at the very least remove conflicting provisions from your declaration and bylaws, so that your owners have an understanding based on the documents of what is and isn't allowed once the bill takes effect. So the bill itself is only going to remove statutory barriers to things like electronic notice, voting by mail, and virtual meetings. The bill can't, of course, have the practical effect of crossing off the sections of your documents that say how meetings must be conducted or how notice must be given to your owners. And the only way for your documents to be changed to, at a minimum, not conflict with the statute is for you to adopt an electronic notice amendment. So it can be a useful tool for eliminating conflicts with the document and for sort of precluding owners from pointing to the documents as a reason to say that you're doing something wrong when in fact you're doing something consistent with the new statute. And Ken had an example of this last week. I don't know if you want to share that story really quickly, Ken, now. Do you want to do that?
Sure. We had a community that was looking to amend their bylaws, and all they were trying to do was eliminate the requirement that the annual meeting be done in the first quarter of the year. And so we worked with the manager and we put together a ballot that was sent out for a vote by mail. And two of the owners wrote long emails back to the manager objecting to the ballot by mail because the bylaws had a specific provision that said that the amendments to the bylaws had to be done at a meeting of the association. And they, of course, were completely unaware of how the statutes were modified under the governor's proclamation. And in response, they also didn't care that the proclamation had been modified because they're convinced that their community must comply with the bylaws as written for their community. They don't accept a priority of documents might exist or a priority of statutes over their documents. And so, we've seen this for years with other communities where they will have old provisions in their bylaws that they just never updated, and someone who is fixated on that language. So it's one of the reasons why you might want to update or amend your documents is just so that you don't have these objections from the longtime residents who have come to expect things to be handled a certain way.
Thanks, Ken. All right, moving on to the next question that was submitted. One of our association managers contacted us and said they were reading through the condo law handbook and essentially summarized the provisions of WUCIOA that they think apply to pre-existing communities. So boiling it down to a simple question rather than reading the whole paragraph that was submitted, the question is, what provisions of WUCIOA are applicable to pre-existing communities? And briefly, for anyone who's not familiar with WUCIOA, if you're again new to us today, it's the Washington Uniform Common Interest Ownership Act. It was adopted in July of 2018. So it's a new common interest ownership statute that for sure applies in its entirety to any community association created after July 1st of 2018. But certain provisions of it also apply to pre-existing communities. So for your information, the statute has a section that talks about the applicability to pre-existing communities. And that section is 64.90.080. So that's the section that you go to look at what sections of WUCIOA apply to communities that were already in existence before the statute became law. And that specific section calls out sections 525 and 545 of WUCIOA. So 6490, 525 and 6490, 545. And it says those two sections are specifically applicable to pre-existing communities in Washington state. So whether you're an old act condo, an HOA, a new act condo, whatever statute you were formed under, sections 525 and 545 apply to your communities per the applicability section. Section 525 is the section on ratification of budgets. So this is one section that we've talked about a lot in these Zoom Q&As. And in a few moments, I'll recap the requirements of what you're supposed to send to your owners before your budget ratification meeting in order to make sure that your budget complies with WUCIOA. And the reason we're going to recap that today is because we know a lot of communities are approaching their fiscal year end or year beginning date. We know a lot of our communities, their fiscal year tracks the calendar year. And for those that don't, many of them split the year in half and start on July 1st. So we'll recap that in just a second. So the 525 is the budget section and it applies to pre-existing communities. 545 is about reserve studies and it applies to pre-existing communities. And 545 also specifically says that your study has to comply with, or the contents of your reserve study have to comply with 550. So although 550 on its own doesn't have a specific call out in the applicability section, 545, which does apply, says the contents of your reserve study have to be consistent with the requirements of 550. So part of the question that was submitted to us also suggested that 555 and 560, both of which also pertain to reserve studies, are applicable to pre-existing communities, and neither of those sections applies to pre-existing communities. 555 is the provision that allows owners to demand a reserve study if a community doesn't have one. And both the HOA Act and the Condo Act have nearly identical provisions. 560 is related to the penalty if there is no reserve study, but neither 555 or 560 actually applies to pre-existing communities. And there's one other provision that is helpful for people to be aware of. RCW 6490-095 is a section within WUCIOA that makes it really easy for pre-existing communities to adopt or to amend their documents and to bring their communities under the umbrella of WUCIOA. So if you want to adopt WUCIOA as your governing statute, 6490-095 makes it easier to do so than it might otherwise be based on the requirements of your governing documents for amending those documents. So Ken, do you think I covered all of that clearly, and do you have anything you wanted to add?
No, I'm good. Thank you.
Okay, great. So very briefly, before we move on to the next question that we had submitted to us, we did want to recap RCW 6490-525 is the section that pertains to budgets and the ratification of budgets for community associations. And I will copy and paste the text of the statute into the chat, as well as a link to where you can find the statute in a moment. But I wanted to recap for you what you have to include in your budget disclosure, which is mailed to your owners in advance of your budget ratification meeting, in order for your budget to comply with WUCIOA. Part of why we're covering this again is, of course, because we have some communities where their fiscal year is ending soon, and so you guys might be in the middle of your budget process for your next fiscal year. Another part of why we're covering this is that, as we shared last week, we have been doing some free budget reviews. It's an offer that we started making about 6 weeks ago and that currently extends through the middle of May, where we are looking at your most recently ratified budget and telling folks if they complied with WUCIOA or not. And unfortunately, well over half of the budgets that we have reviewed failed to comply with WUCIOA in one significant manner or another. And in general, it had to do with these categories of information that you have to include. And so the statute, the list says the budget disclosures that you send your owners has to include the projected income to the association by category, the projected common expenses and specially allocated expenses by category. Almost all of the communities that we reviewed, their budget included that information, both of those categories of information. You also have to include the amount of the assessments per unit and the date the assessments are due. That one was kind of tricky. Most of the budgets that we reviewed had a statement or a spreadsheet somewhere that said, you know, the quarterly assessments are X, or monthly assessments per unit based on percentage allocation are this many dollars per month. But a lot of them forgot to include a specific statement that says something like, assessments are due once per month on the 1st of each month, or assessments are due quarterly on the 1st of January, April, you know, and so on. So including a specific statement of when the assessments are due is necessary. The current amount of regular assessments budgeted for contribution for the reserve study. So somewhere in your budget, there needs to be a line item if you're contributing to a reserve account. There needs to be a line item for the amount of the assessments, the regular assessments that are budgeted for contribution to your reserve account. There needs to be a statement of whether the association has a reserve study that meets the requirements of 6490-550. So you could make it as simple as, does the association have a reserve study that complies with RCW 6490-550, and then check a box that says yes or check a box that says no. If so, you also have to include the extent to which the budget meets or deviates from the recommendations of that reserve study. So if the reserve study recommends that you contribute $200,000 to the reserve account this year, and your budget only is mandating a contribution of $100,000, you need to call out that difference. And you also need to include the current deficiency or surplus in reserve funding expressed on a per unit basis. This is another one of the biggest mistakes that we are seeing. For associations that do have a reserve study that complies with WUCIOA, many of you are relying on the reserve disclosure forms that are prepared for you by your reserve study professional, which we think is very reasonable. However, almost all of those forms that I have seen contain an average surplus or deficiency, not a per unit surplus or deficiency in reserve funding. And because the statute specifically requires that be expressed on a per unit basis, you need to make sure that your disclosure includes that information. And if it doesn't, the good thing is 550 contains a really simple explanation of how you calculate the per unit deficiency. I'm just going to say deficiency. It says surplus or deficiency in the statute, but the vast majority of clients are not operating with a surplus in their reserve account. But the statute does make it fairly simple to calculate the per unit deficiency that your association is dealing with. And if you're already producing a spreadsheet showing all the different percentage allocations within your community and the dues for each percentage allocation, then just add a column that also then calculates and shows the per unit reserve deficiency. So that was kind of a lot. I'm sure for those who are new to this subject matter, that felt maybe a little bit like drinking water from a fire hose. So I'm going to let that percolate and move on to the next question, unless Ken has anything he wants to add. But also, if you guys have questions, please do put them into the chat.
Yeah, the reason we're so concerned about this is that the statute has a very specific penalty if you do not provide the required notice. Most statutes will tell you what you're supposed to do. So, the statute will tell you to have open meetings, but it doesn't have a penalty or tell you what happens if you fail to have an open meeting. It'll tell you to do a reserve study, and it says what the penalty is if you don't do a reserve study. And the penalty is just, you have to do one if the owners sign a petition asking for one. The problem with this notice requirement in 525 is that Section 1B very specifically states, if you do not provide the required notice, that the budget that you had last ratified continues. It does not give you the discretion to increase the dues and collect it. And so if you have a unit in delinquency, you're setting up a difficulty for your attorney to actually legally collect this additional increase, because the statute has a very specific and clear direction on what your budget is if you fail to give this notice. And so we're trying to avoid going into a court and asking for an increase in dues that has not been properly provided for under the statute. And Gil has a question.
I do. Good. Thank you, Valerie. So here's a question from one of our community association managers. Does this mean that beginning July 1st, late fees will be can be charged? Yeah. Can late? So you were talking about the 2051. Yeah.
Yes. I think the answer to that question is that we don't know that. So currently, the proclamation, it remains in effect, and we don't have any indication, or there's no indication that it's going to be rescinded before the bill is signed into law. What could happen on July 1st when this bill takes effect, and these provisions regarding remote meetings and electronic notice and voting by mail are actually codified in the statute, is the governor, one of two things could happen. The proclamation could be rescinded in its entirety, or the governor could just modify the proclamation so that it only prohibits late fees and interest and no longer discusses those issues that are going to then be covered by the statute. So that's a long lawyer answer, but basically we don't know what's going to happen when it comes to late fees and interest. Right now, we are following very closely what the state is doing about things like the eviction moratorium and foreclosure moratorium. And the reason that we're following those is that we think those are a good indication of what the governor will also do when it comes to late fees and interest for community associations. So
okay, so we have a board member that would like some additional clarification. So the Senate Bill 5011 defers to governing documents in order for these updates to take effect for any given association. Is that correct, or maybe not? SB 5011 consistently says, notwithstanding any inconsistent provision in the governing documents.
So notwithstanding is basically lawyer speak for, we don't care what the document says. This statute applies.
yes.
So the notwithstanding is a way of recognizing there's a conflict between the statute and your document. And it's basically saying, we recognize there's a conflict, this statute controls.
So in other words, yes, thank you. So in other words, I think the board member was reading it as the governing documents would control, and we think the opposite is true. All right, I think that that's everything that we are going to cover about budget ratifications, unless we get more questions in the chat. And I wanted to move on to the next question that was submitted to us in advance of today's call. And it has to do with Ring doorbell cameras. So the question is this: I'm hoping for a clarification regarding video doorbells. We recently had a former board member in a multi-story condo with shared hallways assert that doorbells, Ring doorbell cameras, or not just Ring, sorry, doorbell cameras, are illegal in Washington state. The board member cited RCW 9.73.030 as a prohibition on recording private conversations. Can you speak to this and whether a common hallway, such as in a condo or a front porch in a single family HOA, are considered areas where one should have the expectation of privacy, and are these types of devices illegal? So the short answer to this question is that you have no expectation of privacy in a hallway, a common area hallway in a condo building, or on someone's front porch. The places where you have what's called a reasonable expectation of privacy are kind of common sense. If you're in your bedroom, if you're in your bathroom, if you're inside your house with your doors and windows closed, spaces like that that cannot be seen from, say, a public sidewalk or your driveway or the road as somebody's driving by, those are places where you have a reasonable expectation of privacy and should be able to rely on not being recorded on video. Okay. The other thing is that the statute the board member in this question was relying on does not prohibit recording video. It only prohibits recording private conversations without the consent of the other party. So to the extent that your doorbell video camera only records video and not sound, then even if there was some expectation of privacy, that, or even if that statute were brought into play in some way, it would not violate the statute if you were only recording video and not sound. So we think that we're not really sure why. We understand that some associations like to control things like the appearance, for example, within the hallway of their community. We're aware of communities where they dictate what your deadbolt should look like and what your door handles should look like. And so to the same degree, we can understand that there might be a community where they want to limit or prohibit things like, you know, doorbells in the hallways. And certainly to the extent that what you're dealing with, including the door or the hallway itself, is a limited common element, an association has the ability to regulate that. But when it comes to privacy concerns, we think that there is a very low risk in having something like a Ring doorbell camera. So there's a question in the chat, 2 questions on this one. What about a camera in the backyard that records the neighbor's yard as well? So this speaks to that expectation of privacy thing, right? If you can see the neighbor's backyard from your backyard, I'm not saying that it's a good idea to specifically record their backyard on purpose, but I'm not sure that a space that can be easily seen from a neighboring property is a space in which you have a reasonable expectation of privacy. So actually there were 2 questions, but they were more or less the same question of whether you would have a reasonable expectation of privacy in your home. So Ken, I don't know if you want to add some comments to that.
Well, there are court cases that relate to video recording of neighbors. And the courts have held that if someone can see into your garage, even though it may be a private space, they can see into the garage from the public street. There's no prohibition on the neighbor recording. The court basically held that you could close your garage door if you wanted the privacy, that you weren't allowed, you know, there was no legal right to prohibit the person from recording. And there was also a case where the court basically commented that if a telephone repairman could see into your yard from the top of his telephone pole, you had no expectation of privacy in that regard also. And the video recording was not a violation of any laws. So these are issues where we have some examples of the court's rulings, and they have pretty much gone entirely in favor of, if it can be seen from outside your home it's not private enough to be violating any laws, and people can record. I think it's not reasonable to expect that conversations are going to be private if you're standing in your backyard talking. So if someone were to record you, I think you'd lose in court under the statute on privacy. So it's, you know, some of it seems kind of reasonable, but even the cases that relate to audio recordings, the courts have been very limited in enforcing it, because they've even held that meetings with 1 or 2 people in a private conference room did not have an expectation of privacy, depending on the circumstances. So I know one case was employment related. If you and your boss were talking in a room, even if you think it's a private conversation, the courts have held there's no expectation of privacy because you're in your workplace. So these what might be common sense ideas about privacy do not translate into how the laws have been written or how the courts have interpreted them. The common hallway is almost certainly going to be considered a non-private place, so the camera and the recording are to be okay. And outside spaces, if they can be seen from your neighbors' yards, they are going to be available to those neighbors to take pictures.
You know, as you were talking, Ken, I was thinking about, I had a couple of friends over just in the backyard. We're all vaccinated, so nobody worries that we're being risky, but a couple of friends over this past weekend, and it was a bunch of single moms hanging out together with our kids, and they were talking about dating and things like that. And it occurred to me then that our neighbors could hear the conversation. And so, you know, I'm always kind of aware of that and make sure that we're not, you know, we have neighbor kids that live next door, so make sure that we're mindful of that. And so I think, you know, that's just a practical example of the lack of privacy in our backyards, even when they're kind of bigger, like mine happens to be. So I think that I have covered all the questions that I was set to cover. Gil, did you have something that come in?
Yeah, from one of the community association managers, it says, does section 5, part 2 say, except as restricted by the declaration, bylaws, etc.?
I'm assuming they're talking about 5011, and honestly, I'd have to read through it and find that. So that would be a good question for you to submit by email, unless you happen to know what they're talking about off the top of your head, Ken.
Well, I think the way that the statutes are currently written, especially the Nonprofit Corporation Act, is it allows voting by mail and electronic attendance at meetings only if it's provided specifically in the bylaws for the association. And so the governor struck those provisions so that it does not have to be specifically provided for in the bylaws. What I think the new statute is doing is allowing a set of bylaws to be written that does restrict the process by which you vote. So it doesn't eliminate the ability of an association to require voting in a specific manner, but it doesn't require that it be included in the document. And I know that's going to sound confusing to a lot of people, but most documents are silent on issues. So most governing documents are silent about voting by mail. They just don't have a provision on it. So by removing the requirement that it be in the bylaws, the statutory change and the governor's proclamation allow it. If your bylaws had a provision in it under section 5 or the new statute 5011, if it said specifically voting may only be conducted in person at meetings, then I think that that would probably still control over the statute, because the statute is trying to eliminate that sort of issue of silence rather than limiting your ability to do voting. But I guess we'll address that more as we move closer to the bill taking effect.
I had one other question that just came in to me directly, and I think it's a relatively easy one for us to answer. Our HOA consists of 5 directors, 4 at large, which are voted on by the owner, and 1 commercial director. The commercial director never participates and is willing to give his voting proxy to a different homeowner. Your thoughts, or we can cover next week if you prefer. The way I read this question, it's essentially this: can a board member give their vote as a board member by proxy to another person to vote on their behalf? And if that's the question, then the answer is no. Board votes cannot be given over to someone else by proxy. Ken, did you have a different interpretation of the question or anything you want to add on that?
No, I agree that the commercial owner cannot give a proxy for a board vote. The commercial owner probably has the right to appoint a different person rather than themselves as the board member. So if the commercial owner really wanted to allow someone else to vote in their place, he just puts that person in as the commercial board member, and that person can vote in their place. But Robert's Rules of Order and WUCIOA are both very specific that a board member cannot make an informed decision based on discussion at a board meeting if they have given a proxy to somebody else. So WUCIOA is very clear. It prohibits proxies for board members. Robert's rules are very clear. It prohibits it. So even though you've got the Condo Act and the HOA Acts silent about it, we are quite confident that you cannot meet your duty of care as a board member if you have given a proxy to somebody else for your decision-making authority.
Thanks, Ken. I just wanted to let everybody know that I put a bunch of links and stuff into the chat, and I know the chat moves kind of fast for people sometimes. So I wanted to remind you that especially if you're on a computer, as opposed to listening to this on your phone, you can download the contents of the chat if you would find that useful, so that you have the RCWs and the budget information that I just put in there. And the way you do that is that if you're in the chat window and where you would normally type your message, just above that to the right, there's an ellipses, 3 little dots and a button. And if you click on that button, there's an option to save the chat. So in case it's helpful for you today or otherwise to save the chat and have that information afterwards, feel free to do that. And I am done with my section of the questions, Ken, so take it away.
Okay, so one thing is just a reminder that we're about 5 weeks away from many of our communities opening up their swimming pools. And so we'd like boards to be proactive in just, preparing however you're going to. So if you need signs or furniture or cleaning, get ready before the weekend arrives. The second thing, which has come up for a couple different clients this last week, is what I'm going to refer to as retroactive rule changes. And this is where an owner has put a request into the board to do something which the board does not want to allow, but cannot find anything specific in their governing documents to prohibit it. And the question sort of is, well, can they immediately adopt a new rule to prohibit this new behavior? And, I would say in many respects, we would defer to the notion that you can't change the rules after the application comes in. On the other hand, there may be other provisions of your declaration which you can rely on to prohibit something that are more general. So you've got in almost every set of CC&Rs and condo declarations a general prohibition on doing anything that is a nuisance or offensive to your neighbors. So if there's a way for you to characterize the requested behavior, architectural change, whatever it is, as a nuisance or offensive behavior, then it would be something which you would already have the power to deny. But it's not something that, you have to be able to point to something and demonstrate that that is a reasonable conclusion on the part of the board in making its decision. So if you have no rules that prohibit pets or dogs, and someone wants to bring a dog in, unless you can demonstrate under the general nuisance provision that the dog is going to be a nuisance, you probably cannot just immediately adopt a rule saying no dogs and then prohibit the dog. We have had cases where we will tell the board, go ahead and make a reasonable decision based on your current rules for this one application, and then change the rules to match what you want for all future applications. The fact that you've allowed one does not mean you would have to allow all the others going forward. The other question which we had come in, which does not have a good answer, is about hoarding. And this is going to be primarily a question that relates to condominiums, because people hoarding in their own single family homes generally don't bother their neighbors too much, though we have seen it happen where the backyard is filled with garbage. And there's not a good answer. Almost all of the CC&Rs or condo declarations will have the general nuisance provision, and it's probably pretty easy to apply that provision to a hoarding situation, though it may be specific to the circumstances. One of the things you need to do is actually demonstrate that it is affecting the building in some negative way. We've had hoarding situations where the hoarders were very tidy people. You couldn't walk through their unit, but they were very tidy in how they kept all of their belongings. We've also had hoarders where they're saving all of the garbage and food waste, and the home was a health risk because of the problems in it. So one of the things we do recommend is that if you could have an objective outside person evaluate the situation, then it's going to be easier for you to enforce a rule or a violation against that owner. So we have had engineers come in and examine condo units to determine whether or not there was enough extra weight that it was going to structurally affect the building. We have had people come in and evaluate whether or not the health and safety conditions of the home were such that it was a violation or a hazard to the community. We have also stressed that you should try and work with the owner as much as you can. Frequently, the owners are, they would like to do better, but they just don't have the mental capacity to do better. If you have family members or friends or church groups that are willing to work with these people, those are often a much better option than trying to use the power of enforcement under your declaration. Sometimes all you can do is get sort of partial compliance. You might get all the trash and the food waste out of a home, and it may be a temporary fix instead of a permanent fix. But that may be enough that satisfies your immediate needs. Sometimes we find the hoarders are not actually the legal owner of the property, so you can reach out to the legal owner of the property to deal with the issues. There are, some mental health providers that specialize in helping with hoarding situations, and we do recommend you reach out for those. We would recommend you try alternative dispute resolution provisions like the mediation clinic, perhaps with CAI, or the mediation clinics at the law schools in Seattle. So it's usually a multi-pronged approach where you are trying to get the cooperation of the owner, who frequently will recognize that they have a problem, but not know how to solve the problem. And we have seen neighbors sometimes volunteer to help clean out units, and that was something which was a little more acceptable to the owners. And it's also something which you may be able to accomplish without a significant amount of expense. The neighbor, the owner may allow their neighbors to help them when they would not allow a contractor to come in and do the same work. So if other people have ideas on how to deal with hoarders, I'd actually be interested in knowing how you've handled it, because this is something where we have no good legal solution in most cases, even though, sure, if you can demonstrate that this is a hazard or nuisance to your community, you have the legal right to go into court and get an order demanding that they clean it up, and then you could enforce that order. It's just a very expensive and time-consuming process, and it's one that most people would not think of as being a compassionate way of dealing with your owner.
Ken,
So-
I just wanted to offer briefly a comment, and I hope that I did not miss you already covering this, but some counties actually have like a hoarding task force at the county level. I'm pretty sure King County does. I'm almost positive Pierce County does. I don't know about Snohomish County or the other smaller counties in Washington, but that's another resource that could be helpful for you if you are dealing with a hoarder in one of your communities. So if anybody else has ideas or thoughts on this, pop them into the chat. And I'm going to ask Ken another question that just came up that's unrelated while you guys are typing those thoughts, or you can unmute in a little bit as well. Ken, there was a very general question that just got posted to the chat, which is, are there rules on political speech?
Well, there are clearly rules about political signs by which we would refer to campaign signs. Our law office has taken the position that other types of political speech, so like the signs which say support your local police or Black Lives Matter, we believe that they are probably also a protected form of free speech, and that we believe they should not be prohibited, even though they may be regulated as to the size of a sign or the location of the sign. And so we think you can adopt reasonable rules, but we think that you're likely to get into trouble if you flat out prohibit all forms of political speech, even if they are not related to a specific ballot measure or an election. I don't know if I can offer anything more specific than that.
Well, the question was very general, so the person who asked it can feel free to email Gil with, if you have something a little more specific. Of course, it can't get too specific because of the nature of the general information we're able to provide here. The other thing I think is probably helpful for communities to remember when trying to regulate speech of any kind, but in particular, either political speech or religious speech, forms of speech that are protected, is that you're not just worried or concerned with what's legal, what is allowed in terms of how you can regulate speech, but I think you also need to be aware of how it can create bad publicity, not to put too fine a point on it, for your community if you do regulate certain types of speech. So just be aware that you don't want to just be aware of the legal minefields. You also want to be aware of the sort of, political, not to, you overuse the word, but the other pitfalls that can exist when regulating political speech or other forms of protected speech.
Right, and I
Go
would
ahead.
offer towards that also, one of the things which I really recommend you do when you're trying to tell someone they can't do something is also tell them what they can do so that they can accomplish something similar to what they need. So if you're going to tell them they can't have a particular sign up in their front yard because you have rules, tell them what they can do. So if they can't have a 3x5 foot sign in their front yard, tell them the size they can have and where it can go, rather than to just say, you can't have a sign. And that's, I would say, true for a lot of the problems that we see. If someone is making noise because they're working on their car and you've got rules about noise, tell them where they can work on their car or what hours they can work on their car without violating your community guidelines. So if they're working late at night and it's violating the noise guidelines, tell them they could do the work during the day. If they've got the car in their front driveway and they're not allowed to work in the front driveway, tell them they can do it inside their garage or they can do it in their backyard if it's allowed there. So in other words, help them to solve the problem they have or their need, in addition to complying with your governing documents. And you'll have a much easier time with getting cooperation from those owners.
I don't see any other questions in the chat. Gaylor, do you have anything that we're not seeing?
So the back to the political political speech comment, they were referring to an individual espousing their political beliefs within a mixed group, but also within a community-based group.
Well, are we talking about you're having a homeowner association meeting and a person starts to give their political opinions?
I'll just offer some general commentary. The association is not, number one, freedom of speech with very few limitations is a protected right under both our national constitution and the state constitution. And beyond that, an association is not a law enforcement entity. And even if you were a law enforcement entity, even law enforcement has very little ability to regulate free speech, right? Of course, nobody's right to free speech extends to things like inciting violence or screaming fire inside of a crowded theater, things like that. But if what you're dealing with is, homeowners gathering in the cabana or on the pool deck or at a community barbecue and somebody talking about their political opinions, it might be awkward to deal with that, but there's certainly no ability for an association to regulate that. If what you're dealing with is a homeowner who decides to stand up at a board meeting or at an association meeting and start, kind of going on and on and on about their political point of view, I think that there are ways you can regulate orderly behavior within association meetings. And it really doesn't have to do so much with the content of the owner's speech. You're not shutting somebody down because of their political opinion. You're asking them to limit their comments because they're being disruptive to your parliamentary process, so to speak, within your community. So I think making it less about the content of what somebody is saying and more about regulating behavior appropriate to the context that you're in might get you a better outcome. So I don't know, Ken, if you want to offer additional comments.
No, I think that it starts to become too specific. If you need legal advice on what you can do in a specific situation, talk to your association attorney.
Yeah. And I think that is all that we have for today.
There's just a couple of comments that have come in. Let me just see. Okay, so there was a question last week about the speed bumps and where they were constantly asking for information. We actually did handle this last week. So did you want to summarize? It was one of the community association managers, Valerie. Did you want to, where the homeowner was coming into the management company, taking up like an hour of the manager's time. Did you want to summarize that again, or should we just refer them back to last week's YouTube?
I think refer them back to last week's Zoom Q&A, which is on our YouTube channel.
Yeah, okay. And then one more question came in. Is there a statute of limitations on the ability to enforce against unapproved law changes? What if the violation, apparently it's very egregious, is only visible on Google Earth?
I'm going to let you take that one. Well,
the answer is that it varies by the circumstances, and there are a number of court cases, and sometimes the court case will tell you that it is enforceable, and sometimes they'll tell you it's not. It'll depend on what the change is. It'll depend on how long it's been. There's too many variables to be able to answer that question. And it does look like one other question.
Yeah, no, I think that's it. I don't see anything else. If you have any more questions.
There's one last question in the chat about what about the political content on electronic message boards that are paid for and maintained or managed by the association? And I would say this is a good question. There are a lot of communities that have sort of we'll call it a public forum or an owner's forum. And I think that you could adopt rules regarding the content on those boards. We actually recommend that you have rules that would prohibit harassment or some kind of a negative comments on those message boards that would be targeted towards individuals or groups of individuals. And you could certainly, I think, adopt a policy that these message boards were not for business other than that of the association. And you could define that to exclude religious or political beliefs. But it may be difficult to enforce, especially if you are not having somebody check every comment before it's posted. You start to run into the same problems that Facebook and all these other more public sites have on, how do you draw a line and what's what's allowed, what's not allowed. I can have an opinion about, wanting to limit things to just what's important to the community, but someone else will tell me that they think it is important that these political comments be allowed so that the neighbors know what they're thinking. And I don't think you're going to have a single correct answer on that. I don't think there's any requirement that you provide a forum for free speech. So I think you can shut down that forum, and we've had many clients who have shut down the forum as the way of solving the problem. If they can't determine what is and is not appropriate speech on that forum, you just eliminate it altogether, and then you don't have that challenge.
Okay, so I think that wraps up today's Zoom Q&A. If you have questions for next week, be sure and get those to me by Tuesday. You can send them to info@condolaw.net, info@condolaw.net. Thank you, Ken and Valerie, for your time this morning, and thank you everyone for participating. We'll see you next week.
Thank
Take
you,
care.
everybody. Bye.
Have a good one. Bye-bye.